You're listening to Systemic Error Podcast. The failure was designed.
Justice Jackson delivers blistering legal smackdown of Clarence Thomas Dissent, based on an article by Sarah K. The court kept birthright citizenship. The damage came from the dissent. Our, not performance. The immediate institutional power in this story sits, where it always sits, with a Supreme Court majority that rejected Trump's birthright citizenship order. Chief Justice John Roberts wrote the opinion. That is the hard fact. The Constitution, for the moment, held. But the more revealing power is in the dissenting machinery around the court. Justice Clarence Thomas, joined by Samuel Alito and Neil Gorsuch, used the case to press a narrower, more evasive reading of the 14th Amendment. That is where the political work is happening, not in the majority's formal victory, but in the attempt to hollow out the meaning of citizenship while pretending to be merely interpretive. Trump's order needed legal cover. Trump issued the executive order. That is a decision that forced this fight. The court did not invent the assault on birthright citizenship. It was asked to clean up after it. That matters because this story is not about a constitutional misunderstanding drifting through the system. It is about a deliberate move to strip citizenship from children and force the court to either ratify it or stop it. The order was the instrument. The justices were the enablers or the barrier. Trump set the pressure point. The court decided whether the pressure would become policy. Thomas's trick history as evasion. Jackson's concurrence taught its Thomas because he offered the most revealing form of misdirection. He wrapped himself in colorblind language, while recasting the citizenship clause as a narrow remedy for enslaved people and their descendants. That is not neutral legal analysis. It is an effort to shrink Reconstruction into a one-time compensation scheme instead of a constitutional reset. Jackson's rebuttal cuts through the performance. The Reconstruction amendments were not a limited repair job, but an anti-subordination project. That distinction is the whole fight. If you reduce the 14th Amendment to a special case for a past injury, then citizenship becomes conditional again. If you read it as a structural reset, then the order collapses under its own cruelty. The court's real pattern. The source article treats this as a dramatic intra-court clash, but the larger pattern is more damning. A conservative jurisprudence has been steadily laundering hierarchy through the vocabulary of principle. Colorblindness becomes the mask. History becomes selective memory. Black political achievement gets recoded as legal excess. Jackson's footnote, citing cases denied by the court, points to the deeper problem. The court does not merely interpret equality. It decides when equality will be narrowed, delayed, or ignored. Thomas's dissent fits that pattern cleanly. It is not confused. It is disciplined. It tries to rename a constitutional guarantee as a special favor and then act shocked when the text resists. What Jackson was really answering. Her concurrence is aimed at more than Thomas's argument. It answers the larger judicial habit of sanitizing harm. The dissent wanted to turn a citizenship fight into a doctrinal puzzle. Jackson refused that frame. She named the Reconstruction amendments as an anti-subordination reset, which is exactly what the reactionaries in this case do not want to hear. That is why the praise from academics in the source material matters less than the substance. The point is not that Jackson was on fire. The point is that she identified the political architecture behind the legal language. The dissent was not just wrong, it was participating in the familiar project of making exclusion sound jurisprudential. Larger pattern. This case shows how authoritarian instincts survive inside formal legality. First comes the executive order, then comes the interpretive rescue attempt, then comes the respectable language meant to launder the outcome. The court majority stopped the order here, but the dissent chose the next round already waiting. A deeper lesson is not about one justice's rhetoric. It is about a legal class willing to treat citizenship as a theory problem while politicians and judges decide who belongs. That is how constitutional rights get weakened in plain sight, not only by direct attack, but by elite institutions that turn exclusion into a debate over style. You've been listening to Systemic Error. Thanks to Alternet for today's article. With the automated voice of Kristen, thanks for listening.